Hello members, welcome back to our platform Agora Legis, and where we shall discuss today contract law, and we are going to dive into the topic of an invitation to treat. And last time we talked about an offer and we looked at the essence of an offer, and today we're going to differentiate it with an invitation to treat, because this is a problematic in contract law where people always get confused. Is it an offer or an invitation to treat? So, without further indulgence, I'm Counsel Ben, and let's jump right in. By definition, an invitation to treat has been defined according to the Black's Law Dictionary 11th edition on page 733 as an expression of the willingness to negotiate the terms and conditions of a contract. So here we are only looking at someone who is proposing, is making room for negotiation of terms of a given contract. And in simple terms, other people define it as an offer, to receive an offer. Someone is offering you to come and give you offer. So he's offering to receive an offer. And the purpose of an invitation to treat, firstly, it is to invite others to make offers. Where for example, you are selling your phone, you're just saying that my phone is for sale. So there you are inviting others to make their offers, and for you, you are only the receiver of an offer. So someone who is giving an invitation to treat is, in other words, the offeree. He is not the offerer. He is only the inviter, but he is the offeree, the person who receives the offer, and it is upon his discretion. Secondly, the purpose is to give discretion to the inviter, either to accept or refuse and deny the offer. And thirdly, it is it does not show intention to be legally bound. So here, someone who is inviting others to make offer, he is not intending to be legally bound by anything. It is only after acceptance of an offer from outside that he becomes bound by that particular contract. After defining the concept of an invitation to treat and looking at the purpose of the invitation to treat, we are now going to look at some of the examples and illustrations on how we define what an invitation to treat is. And we shall start by the first example, which are goods that are displayed on shelves in service stores. In the case, for example, of Pharmaceutical Society of Great Britain versus Boot Cash Chemistry, in this case, the court held that the contract was formed when the goods were presented at the cash desk for purposes of payment, but not when they were taken off the shelf. So here we are purposefully looking at the fact that it is only when you take those goods from the shelf and come to present them at the payment desk, that is when the contract is formed. But as long as he has not yet taken the money, the person who is at the payment desk, maybe in a supermarket, when you go, for example, and you take something in the supermarket, there it is still an invitation to treat. They have not offered you anything yet. But when you present them to the cash desk and you are now to pay, that is when the contract is formed. So let's pay attention to this, guys, and do not confuse it. So that is the first example, as when it is goods that are displayed on shelves in service stores. Secondly, we are looking at the goods that are displayed on shop windows. For example, in the case of Fisher vs. Bell, a case of 1961, the shopkeeper was charged with offering to sell a flick knife, which was contrary to the law at the time. But the court held that the fact that it was only displayed in the shop window, it did not amount to an offer, but rather to an invitation to treat. So, guys, let us be very careful with this. When someone only displays something, even if it is for sale, but It is only displayed in a shop window. He did not ask you to come and buy it, or he did not contact you personally that I'm offering you to sell this. We shall differentiate it with another case later on. Like, as long as he did not offer you expressly and you alone, he did not contact you personally that I'm I'm offering you to sell this, for example, or this other thing. But it is only a good that is displayed in a shop window, for example. It is not an offer, but only amounts to an invitation to trade, as seen in the case of Fisher vs. Bell. Thirdly, we are having goods and services that are displayed in newspapers. And here we are looking at the fact that someone is displaying something in newspaper. If he did not take sufficient steps toward making it sufficient to amount to an offer, it is not an offer but rather an invitation to treat. This happened in the case of Cartridge versus Crittenden, where he was charged with offering to sell a wild bird, but the court held that the advert only amounted to an invitation to treat and not to an offer. So here we are going to differentiate it with the case of Khalid because it was also almost the same. But here, the smoke ball company in the Khalid case took sufficient steps toward making it effective. For example, they already made a deposit of £1,000 in the bank uh, towards making that offer uh, effective. So we have to be very careful while looking at these facts and differentiating them. The next example, members, is auctions. When goods are displayed for purposes of an auction, they are not offers, but they are only invitation to trade. For example, in the case of Harris versus Nicholson, uh, Nicholson withdrew the goods that he was displaying for the auction, and he was sued because it was presumed that maybe he has breached the contract, he has breached an offer. But the court held that the goods that were displayed for the purpose of an auction did not amount to an offer, but rather to an invitation to trade. The next example, members, is invitation to counsel tenants to buy property. When tenants of a given council are written invitation to buy the property by the council, it is not an offer but rather an invitation to trade. Uh, this happened in the case of Manchester City Council. No, Gibson versus Manchester City Council. In this case, the City Council wrote that the council may be prepared to sell the property to Mr. Gibson. And when it changed its mind, Mr. Gibson sued, but the court held that it did not amount to an offer but rather to an invitation to treat. First of all, because of the uncertainty of the words, but also because it is only an invitation, but not an offer. So but this case is to be differentiated from the one of Stores versus Manchester City Council, because in this one, if you read the fact, the document was entitled uh, "Agreement for Sale." It was not just a mere invitation. So we have to be careful when there is certainty of words in a given invitation. It makes it automatically an offer. So we have to look at the certainty of words, but also the circumstances in which the invitation is made. Next point, we have a mere statement of fact or a mere statement of price, sorry, does not amount to an offer, but rather to an invitation to treat. When someone says that this is the least amount I could sell my phone to, it does not amount to an offer, but rather just to an invitation to treat members. And this happened in the case of Farsi, Harvey versus Farsi, whereby uh, Mr. Harvey was saying that the least amount I could sell my property is £900. But The other party thought that it was an automatic offer, and while suing at court held that a mere statement of price does not amount to an offer, but rather to an invitation to trade. Unless there is certainty of words, it is not an offer, but only an invitation to trade. And the last examples include tenders and goods displayed on the internet, which amounts to an invitation to trade. So tenders members, this is a call for to make an offer, and goods displayed on the internet, they do not amount to an offer but only to an invitation to trade. For example, when things are displayed on the Jumia app, Alibaba app, Gigi app, they are not offers but only invitation to trade, because it is only a statement that requires further negotiation for a contract to be made. So you are the only one bringing an offer, but not the one accepting an offer. So the one who published his things online, or the one who called for a tender and you to place the bids, are not offering, but they're only the offerees, because they're waiting for your offers for them to accept or deny the offers. And lastly, members, we are going to look at the situations that do not amount to an invitation to trade and that become binding once they are entered into. For example, we have the first one, which is a unilateral offer, as we saw it in the case of Carlyle vs. Catholic Smoke Ball Company. Secondly, we have a statement of price, but pay attention here, it's a statement of price with an offer. For example, as we saw in the case of Boyd's, Bing versus Boyd's Gibson, where it was a statement of price which was clearly entitled offer to sell, but not just a simple statement of price. And lastly, we also have competitive tendering. These are tenders that include a competition. For example, if I tender something and I say that the highest bid is going to win it, definitely, if you are the one who brings the highest bid, I'm bound to give it to you, because it is my own words that bind me. We are going to look at the next time at the promissory estoppel, and we shall see that once someone has said something, he's bound by it. And as it has been applied in the case of Havela Investment versus Royal Trusts Company of Canada Limited. So guys, that is it for today. We have looked at the topic of an invitation to trade in contract law, and I urge you to subscribe, like and share, comment where you didn't understand, and thank you for watching. It is Agora Legis with Counsel Ben.